All right. Thank you everyone for joining us. Welcome everyone. My name is Nouri Yanaki. I'm the president of the Arab American Bar Association of Illinois. AABAR is proud to present a CLE on the impact of voting rights and election laws on minorities as part of its pioneering biannual diversity and inclusion series. For those that are new to AABAR, we're a bar organization of close to 300 members and have very active committees, including our esteemed CLE committee and judicial evaluations committee. We encourage you to visit our website at AABAR.org to see our prior CLEs, including a presentation on diversity and inclusion in legal education and our presentation on fighting discrimination. As a side note, this CLE is being recorded and for educational purposes. Please keep yourself muted if possible. And in order to receive the Illinois Professional Responsibility Credit, please email us your name and ARDC number at info@AABAR.org, an email address I will place in the chat box for everyone. Without further delay, it is my honor to introduce the moderator for this afternoon, AABAR's co-founder, past president, and co-chair of our CLE committee, the Honorable William Haddad.
Thank you, Nora, and welcome to all of you from Chicago and all around the country. We have a national audience that is more than double what we normally have for a CLE, but that would be explained by, of course, this issue. This is a biannual continuing legal education series that we pioneered here at the Arab Bar Association here in Chicago on diversity and inclusion. And our subject today is the impact of voting rights laws on minorities. And we will have a question answer session at the end of this if we have time. I would ask anybody who has a question to go to the chat room and submit it. And Professor Breen, who's our co-chairman, will address those questions and bring them to the panel. With us today is an expert panel that I would like to introduce to you. We have the eminent Gary Bledsoe. He is president of the NAACP in Texas. He's acting dean at the Texas Southern University, Thurgood Marshall School of Law. He will be discussing equal voting rights for minorities, minority issues with redistricting, voting rights security laws in the states, including Texas, recent challenges to access to the ballot. We have also with us Professor Derek Muller. He is a Bouma Fellow at the University of Iowa School of Law. He'll be discussing the role of states in the administration of federal election laws, judicial restraints on challenges, and the Electoral College. Now, Professor Noah Praetz is from our very own Chicago DePaul Law School, where he teaches election law as an adjunct professor. He heads an election consulting group here in Chicago. He'll be discussing election security and operations on a local level. And finally, we have the eminent Matthew Piers, president and shareholder of Hughes, Socol, Piers, Resnick, and Dim.
Okay, thank you. My meeting just started on Zoom. Thank you.
I'm hearing voices here. Matthew is a seasoned Chicago litigator who can tell us about the realities of election laws and voting rights litigation, their impact on civil liberties, on minorities, and state voting redistricting issues and concerns. I'll ask those who are listening to please mute your your Zoom application, if you would, so that we don't have any interference as we go along. And without further ado, may I bring to you Gary Bledsoe. Professor, proceed.
Thank you so much, Judge. I'm really honored to be with you all today. I want to commend you for your foresight and your interest in this very important topic. I do want to say in beginning that I'm no longer the acting dean at Thurgood Marshall. They have a new dean who's working very hard over there, Dean Bullock. What I'd like to do today is really to kind of focus the attention on what's occurring in Texas, because I think there's always a great concern that what occurs in Texas might occur nationally. And if I give you one statistic, I think that maybe puts it more in perspective. According to the census in 2010, Texas had become 49.4% African-American and Latino combined in terms of the percentage of its adult population. Those numbers have continued to increase. Right now, you have 59 to 60% of the population in Texas that is minority. And I think that, and so even when you look at the voter registration, the minority percentages are close to 50%. And so you see the alarm that many in Texas have in reference to the growing minority vote. So because of the growth of the minority vote in Texas, we have a great antagonism that has arisen to try and suppress the minority vote in a number of different ways. So what I'd like to do is, there are kind of 9 points that I wanted to make in reference to what the state authorities have done to try to suppress the minority vote. One is in the new law that was passed, this SB1 this last time, and primarily my comments are going to come in reference to SB1. And I'm going to take different segments out and discuss those segments. But I think they do spill over into other actions that have been taken by state authorities. There is a desire to intimidate people from registering to vote. Okay, there are, in this new law, there's now a greater interconnection between the Department of Public Safety, the Department of Motor Vehicles, and the local clerks that handle juries. And so where there is an interface that would include the Attorney General that has used their election integrity division to go after individuals that are 80% black or brown. And so that unit has really gone after minorities in terms of election integrity issues, but it's only a small number that they've been able to find, because when you peel back the onion there, the couple hundred they mentioned is only 50 or so, simply because they charge people with multiple crimes. So the number of crimes over 10 years they found is so small, and it's usually minorities. So that's a great concern there, because the idea is if you deport one person, or if you find one person that might be an issue, then you have a lot of publicity that surrounds that, that'll discourage people from registering to vote, even if they're eligible to vote. You might recall that what Texas did a couple of years ago was it came up with this massive purging of anyone that had had any connection with immigration to try to get citizenship papers. And so they wrongfully purged over 100,000 persons. And so I think that kind of issue is continuing to surface, where you're trying to suppress minority registration. Another issue, they intimidate people from voting by prosecution threats, news releases, and things of that nature. They did this, for example, in reference to the voter identification law that was passed in 2011 that we were able to get invalidated by the Fifth Circuit Court of Appeals through a majority at that time that had a majority of Republicans. That's before President Trump was able to put people on that court. But I think that what happened there is, once the court ruled that there should be a compromise and some opportunity for people to submit an affidavit if they didn't have these new limited forms of identification, the Attorney General issued all these news releases that he's coming after you if you make a mistake or what have you, and some local officials did the same thing. So the whole idea was to have a chilling effect on minorities to be able to utilize this mechanism that the court said that they could use. And so there are issues here with all of these crimes, these numbers of new crimes that are in the new election law, that once someone is charged, we've had people like Crystal Mason and Hurwitz Rogers to be charged in Texas, and they clearly did not think they were violating the law. The mens rea requirement in the law has really been relaxed or eliminated altogether for minorities allegedly involved in election law matters. Because when you, and we saw what occurred in Tennessee the other day, right? When the person has even a letter from the probation department saying that she should be able to vote, and they indicted her and charged her with 6 years in prison or what have you for actually registering when she was trying to follow all the right fail safes and all that. So where's the mens rea? I don't know what the mens rea was with Crystal Mason or with Hurwitz Rogers. So you might look at those two issues. Early voting is made much more difficult in Texas. We had a Texas Supreme Court of all Republicans that issued a reasonable opinion last time during the pandemic in 2020. And so the legislature wanted to simply annihilate that opinion. So they did that. They made it extremely difficult. Now you have to put identifying information, request the matter, the mail-in ballot in writing. And many of you might have seen Pam Gaskin. She's been on CNN, MSNBC, and others detailing some of the issues she's had in Fort Bend County, where if the information that, for example, that she used 46 years ago to register to vote is different from what she uses now in terms of whether she used a Social Security number or a driver's license, then the ballot application is rejected. And there's also there are other tricks in there, but another trick is you have to have the information twice. And even if you have the information, that's not sufficient, because you have to have the information in the flap of the envelope that is required to be sent, as well as on the form itself. So if you don't have it in both, then the form is rejected. And what occurred was they were late in getting the form out. And so even using an old form that was available on the site and it was represented to be the correct form, the forms were rejected, even though they were provided by the authorities themselves. So you can see that that's having a big impact, in many good faith registrars are having to reject the ballot applications or send back ballots because they were not adequate. So that's a real problem in Texas. And so the early voting is made more difficult because it's limited where you can have it. You can no longer have it in temporary venues. They force you to have it in your local in your offices that may be in other places around the county. So you can't get a temporary site that doesn't have the volume or the activity. You have to use that particular building. You can't use a temporary structure, and there's no reason for that. You can't use any drive-through voting. So all those issues are made to make early voting more difficult. And there's time constraints on early voting. What we were able to find out in Texas is that primarily minority voters use the 24-hour access that Harris County provided last time. So it's black and brown voters that maybe have unusual work schedules and things of that nature who utilize it. They can't utilize it. And it was women who primarily utilized the drive-through voting, and now we can't have that anymore. So it actually discriminates against those groups, those new limitations. So we've got the early voting, the mail-in voting, all those things are limited. You make the voting experience undesirable. You bring up all these new requirements for verification, new forms at every level, so that forms are going to have to be filled out. You've empowered the individuals who are poll watchers that have had discriminatory histories in reference to the interaction with minority voters, and who were really adversarial, antagonistic, bigoted this last election, as well as many others. And one of the issues, for example, was many of the conservative poll watchers refused to mask up during a pandemic, and they wanted to get near voters, and the election officials wouldn't allow them to do that and invade someone's space. Now that's been changed. Now they can do whatever they want. They're large and in charge. They can get exposed to you and subject you to potentially catching the coronavirus, et cetera. And there's nothing an election judge can do anymore. They've taken the law away to where they can't have it. They can go to court and try to get an injunction, but by that time, how many people would you have infected? And there are many laws, criminal laws, that apply to misbehavior. There are many laws that have been that apply to officials here, but there are no laws that apply to misbehavior by the poll watchers. They are now large and in charge, and we have a real history with them, and it goes much further. But the other thing is, with all these new documentation requirements and the affidavits that are required, they're going to be intimidating. People will be more reluctant to assist voters. You'll be subjecting yourself to prosecution. They'll be able to subject or put you against a person because you're supposed, one of the things that now, if you assist a voter, you have to assert that you know that their disability exists. Now, that just seems to be really invasive and well beyond the pale. And so individuals are going to have to divulge private information in order to be able to vote. I think it's really intimidating, the fact that they're doing this. They make it easier to reject ballots after the vote with the use of signatures, and they can use any signature that they have at their disposal. They can get a 40-year-old signature and say it's different from the current signature. So I think that's there are going to be many. We had races, for example, in Harris County back in 2008, I guess it was, when Goodwill Pierre and others lost, but they lost primarily because of the disqualification of ballots. And so disqualification of ballots is a real issue. And so we have to be concerned about that. The laws that relate to election workers, there's one particular provision in the new law that says if there's any practice, any custom, any standard that has the support of law that you're utilizing, that if you vary from that standard in any way, then you've committed a crime if you're an election worker. That is so broad, that is so vague, that is so intimidating, that how are you going to know what practice that you know that someone else believes is required by law? There's no list anywhere for you to look at or for you to reference. So I think that the whole idea is going to be to charge election workers to really cause election workers to be held at bay. We have lost a number of election workers who understand what's actually occurring. To give you guys one example, the county clerk in Travis County is not running for re-election, the long-term clerk in that office, but she was required to go to a grand jury in a neighboring county. We have an election law in Texas that says you can be charged in a neighboring county for an election offense. In other words, unlike any other law where the county where something occurs is where you have to go before a grand jury, the idea here is to get around the urban counties or the progressive counties and to go to neighboring counties. That's what happened to Herbert Rogers and others. So that's a real problem. And they've also created new lawsuits to where people can sue candidates, can sue supporters of candidates for issues. There's a law relating to vote harvesting that seems to really get out the vote campaigns that might impact churches, nonprofit organizations, et cetera, in terms of how they do their work. It's really intended to be intimidating and to prevent people from having effective get out the vote efforts. And, redistricting is done in such a way as to make sure that they're not competitive districts so that there won't be any inertia in the bottom parts of a ballot to actually cause the voter turnout to go up. And so I think there's clearly a voter suppression mechanism involved in this as well. I know
did you want to show some slides? I'm sorry to interrupt you. Did you want to show some slides I don't know if we have time for it, but I think you had some slides you wanted to
Mr. Bledsoe, I did provide to all the PDF in the chat box if everybody would like to access it.
Okay.
Yeah, I think, Judge, that's what I think we were trying to conserve time there. So I think that I have a slide presentation on the election law in Texas. And so we put that in the chat box so everyone can see. But I was going to reference slides 3, 6, 11, 15, 17, 18, 20, and 21 just to make examples. But I know I need to slide 3 relates to the use of law enforcement and how law enforcement is going to be used to intimidate aspiring minority voters, to limit the access to early voting, slide 6, slide 11, one of the ones that starts out with the poll watcher discussion, the mail-in ballot issues on slide 15, slide 17, the signature verification committee and how that's going to be used to suppress the vote. The problem with the new requirements for assistance to voters with slide 18, slide 20 is relating to this new vote harvesting law that creates a criminal law. So if you've got kids in your church that are going to go out, your church, your mosque, your synagogue, what have you, they're going to be subjected to problems in this new civil action that we may have seen with the Texas anti-abortion law. Is the same kind of civil action here, where they're given every Tom, Dick, and Harry the ability to file a lawsuit against a candidate or someone in a candidate's campaign for various offenses, which is going to intimidate and discourage good people from actually getting involved in elections. And I think it's really terrible, but that's just a comprehensive way in that they're trying to suppress the minority vote, even going after the nature of candidates that are going to run, because many people are going to look at this and say, I don't want to subject myself to this.
Well, thank you very much. I think we're going to move on now, if we could, to Professor Muller at the University of Iowa Law School. Proceed.
All right, great. Well, thank you for having me. I wish we could be in Chicago. I'm out here, but it's just as cold out here in Iowa as it is in Cook County today, I'm sure. I'll try to be brief and sort of highlight just a few things to think about, sort of at a pretty big picture about especially the stages of litigation and maybe a little bit of legislation. And I'll sort of talk about three things: redistricting, kind of nuts and bolts of election administration, and then maybe a little bit on presidential elections and the counting of electoral votes. So to start, we're seeing a lot of stories in the media about redistricting in the United States, simply because every 10 years we do it after the census. The census was delayed in part with litigation from the Trump administration, in part because of COVID challenges. We got that data late. A lot of states are redistricting. Many of them are done with it. Others are in process. And then you start to see the legal challenges crop up. But given that we have an election in 2022, that compressed window has yielded a lot of challenges as we're thinking about drawing these districts. So there have been challenges to partisan gerrymandering. The Supreme Court a few years ago said that federal courts are closed for business to hear partisan gerrymandering claims. That's pushed a lot of partisan gerrymandering claims into state courts to say that when legislatures drew these districts, they drew them unjustifiably to entrench one political party at the expense of another. And we've seen in North Carolina just this week, in Ohio a few weeks ago, some of the state courts adjudicating these cases and saying we need to draw different maps on account of partisan gerrymandering. There was a lot of discussion in Illinois thinking about partisan gerrymandering as a concern, especially on the congressional map side. But right now, it's still a map that's in play. There's also challenges in terms of drawing districts on the basis of race. And we can think about this in a couple of different directions. On the one hand, the Constitution forbids you from drawing districts primarily on the basis of race. And we've had claims brought by both white voters and black voters in the last 30 years, to challenge districts to say this is a racial gerrymander. On the other side, the Voting Rights Act, and specifically a provision known as Section 2 of the Voting Rights Act, requires states to draw districts to empower a majority population that is a racial minority if they're geographically compact and have enough community of interest to be able to vote together. And there's a series of ways the courts have looked at it. That's some of the litigation that's happening out of Alabama this week. What are the contours of the Voting Rights Act? What does that look like? I understand there's litigation this week now in Illinois suggesting that an Arab American district ought to be drawn, thinking about what that looks like in terms of Section 2 of the Voting Rights Act. So we can think about this as an additional feature. We're looking, on the one hand, we're not drawing it overtly on the basis of race, while at the same time, sometimes we have to take an account of it because the Voting Rights Act, as a compelling interest, is necessary to remedy past historical racial discrimination, especially where there's racially polarized voting in the states. So we're seeing those things crop up. That's led to a lot of challenges in Cook County in particular, right? As we've seen the alderman districts redrawn, and Black voters and Latino voters in some tension about where those districts are going to lie and who's going to get additional seats as population growth changes across the city. And we're seeing also the Supreme Court hearing these cases, especially the Alabama case that it stayed and said Alabama can institute its maps for 2022. It's too close in time for the election. We'll get to the merits later over the dissent of some justices in the court. But, we're hitting crunch time right now. And these federal cases are heard in front of a 3-judge panel that appeals them directly to the Supreme Court. So anytime these redistricting cases are filed, there's an interesting procedural mechanism, and maybe a reason why you always see news reports about the Supreme Court stepping in for these redistricting disputes. All right, so that's sort of the redistricting side. We can dig into any state, any case you want. There's so many things, so many rich things happening right now as we think about drawing districts. A second thing is thinking about sort of the nuts and bolts rules of administering elections. And appreciate Gary sort of setting up what's happening in Texas. A lot of this is happening at the state level. It's not remarkable every 2 years, especially right after an election when legislatures get together, they start enacting new rules. But there's no question there's significant tension now in the states. As a lot of states had emergency proclamations or changes to their election administrations in 2020 during COVID, changes that courts ordered, temporary changes that state legislatures ordered, coupled with, some let's say, not the most credible allegations of fraud or irregularities in the election. And then questions of the states moving forward saying, what's the best way to do this? We've dramatically increased absentee voting. Is that something we want? It's costly. It requires people to vote months in advance of the election at times rather than on election day where they all have the same information. But it's convenient and it's accessible to many more voters and can increase turnout for those voters who might otherwise have difficulty accessing the polls. There were difficulties with signature verification in the 2020 election, as often happens with trying to verify somebody using kind of this 19th century technology. Did you sign the ballot right? It's a way of verifying your identity. And so some states have been trying to think about, should we use an ID number like Texas has suggested? Now, using an ID number comes with costs because you might not know what that ID number is. It's a lot easier to put your signature on the ballot or on the envelope rather than relying on on an ID number. A number of election officials in 2020 were doing their best in really trying circumstances to administer elections. But at the same time, they would just defy the orders of an attorney general or the secretary of state. We had a few instances of those here in Iowa. There are other instances throughout the country. And there was a tension between statewide rules and local administration. And so what's the proper way forward? Penalizing election officials is a really harsh thing. And yet there are incentives we want for election officials to follow through with the rules that are provided. And so as this tension arises in the states, as states develop new rules that have spillover effects or might alter voter behavior or affect certain subgroups of voters, voters of color and others, we might think about how we litigate these things. And so a lot of the cases that are bubbling up, they're being filed in federal court, and we're seeing it in Georgia and Texas in particular, although there's a few other cases elsewhere. Sometimes they're in state court. And the federal courts are tasked with kind of making a balancing inquiry. They ask, how severe is this burden on the right to vote? And how significant is the state's interest? That was actually what a lot of federal courts were doing in 2020 to ensure there was adequate accommodation for voters, saying a lot of rules about absentee voters and the like were not sufficiently weighty enough to preclude extension of the right to vote in certain other cases because of COVID, because of other things. But, courts go in different directions. Sometimes they'll look at a rule and say, this is just too restrictive and too onerous. At other times, they'll say it pretty marginally affects the right to vote because you have so many additional opportunities to vote. So that's another thing to watch as the courts litigate these cases, how they sort of balance those interests, how the state articulates its interest up against the sort of burdens that are put in place in the system. And then finally, very briefly, we saw some tension about Congress's role in terms of counting presidential election votes out of the Electoral College, January 6th, and the riot and the failed insurrection there at the Capitol sort of being the culmination of that moment. And, presidential elections in the United States are really administered at the state level with the goal of having Congress just kind of count and tabulate the results at the end of the day. And it does that under a provision of federal law known as the Electoral Count Act. But there are some weaknesses in it. One is that it allows one member of the House and one member of the Senate to object to when a state counts its votes, and allows Congress then to deliberate for 2 hours whether or not to throw out those votes. That's actually what happened twice in 2021. Members of Congress objected to counting Arizona and Pennsylvania's votes. It happened in 2005 with Ohio's electoral votes. And there were suggestions that maybe the vice president could unilaterally throw out electoral votes based upon some ambiguities in the statute and some inconsistent history. So there's been a bipartisan effort that's really culminated in the last month, I would say. It's really not dealing with some of the election reform, the Freedom to Vote Act, the John R. Lewis Voting Rights Act, those kinds of amendments that are being made in Congress. It's really a much more discrete question. Can we control and constrain Congress's role when it meets every 4 years on January 6th to count votes, to engage in this ministerial act and move more efficiently? So we could talk about all kinds of details. I could spend hours on that alone, but it's worth thinking about that. It's really kind of a narrow provision, but probably one that has the most likelihood of success at the federal level of getting enacted within the next year, I would say. So those are my sort of three areas of things happening: redistricting, nuts and bolts rules, and electoral count act reform. And I'm, of course, happy to chat more in the Q&A. Thanks for having me.
Thank you, Professor. Let me parenthetically add that in 2015, MENA Americans were supposed to be counted in the census. 2020, the Trump administration banned that. And as a result of that, the difficulty of redistricting Southwest Cook County with Arab American voters is difficult to do without a census. And that also goes for the minority business enterprise opportunities, while all other minorities are included in the minority business enterprise ordinances throughout the United States. Asian Americans, Native Americans, and all the minorities we know. Arab Americans have been excluded, conspicuously omitted. One reason is that there's no census data for disparity studies that are supposed to be done. So our particular minority has been hit by this issue of what people are calling Trump's census ban on Arab Americans that pervades or impedes our ability to partake in redistricting and other programs. I'm going to move on to Professor Noah Praetz from DePaul Law School. You're on.
All right, thanks. It's so fascinating to listen to Gary and Derek. I'll try to be quick and move on to some more reasoned legal scholar. I ran elections. I did all this for 20 years in suburban Cook County, and I'm going to try to bring a little bit of an administrative perspective to the discussion. You know, when I started prior to Bush v. Gore, elections was a logistics game, bringing people and things to a place for an election on a single day. It's like, I call it the wedding planner era. You know, then Bush v. Gore happened, all this new technology, these new laws, the Help America Vote Act. Election officials all of a sudden had to become sort of IT managers as well, legal compliance managers. Then crazy 2016, Illinois in the eye of the storm. The Russians steal some data from our statewide voter registration database, and all of a sudden election officials have to become legal compliance or become cybersecurity managers. Then 2020 comes, and all of a sudden we've got to be communications experts, public health experts. All the fallout after this, we're now in a watch your back era, right, with threats against election officials, and you layer on top of it the redistricting process, which is always pretty difficult. So, you know, looking back at November 2nd, 2020, election officials, nearly 9,000 of them around the country, looked up and did the election official prayer, which was, please, Lord, do not let this be close, because they just don't care. They want to certify the election and get away. November 3rd, most of them looked up, thanked the Lord, said, I'm glad I don't work in Wisconsin, Michigan, Arizona, Georgia, or Pennsylvania. But unfortunately for all of them, at some point in the last year and a half, they have looked up and said, why have you forsaken me? Because election officials are under the gun absolutely and everywhere. So look, policy law is important in elections, but actual administration can have huge impacts. How well the counties and cities do at administering elections will have a marginal effect on turnout, on counting, and incredibly on confidence and legitimacy that comes with a certified result. I was thinking about what Gary said, and a couple of things Derek mentioned. You know, election officials can adapt to legal changes, but I'll point out that the simple design of a form can have huge impacts. You know, in Cook County, our mail ballot envelope had all this legal gobbledygook on it. And when I studied it, I saw we got 4% of ballots back that weren't signed. Okay, that's 4% of voters whose votes won't count without us taking corrective action. We redesigned the form to make it user-friendly and drove that down to 1%. So think about that now with these late changes that Gary was bringing up in Texas, how having a little bit of time to administer the election better, even with bad laws, can help voters overcome what are otherwise barriers. Georgia has a law that says you can complain about voters and allege that they don't live there, and the county official has to now send that voter a letter, tell them there's been an allegation, offer them the opportunity to rebut. Now, it doesn't do anything if the voter never says anything. You know, there's no evidentiary requirement. The voter is not adversely affected, but you can imagine a county administrator saying, I'm going to write this letter in an intimidating fashion. You can imagine another one who's well-reasoned sending the legally required letter that says you don't have to do anything, you're just fine. So administration really, really matters. Elections are super complex, right? Voter registration, voter engagement, poll worker recruitment, training, all this voting technology, election security, foreign adversaries, election integrity concerns now, communicating why it's trustworthy, managing campaigns, candidates, finances. And then when it comes to redistricting, you've got the fundamentals of building ballots and counting votes. So layer this all on top of this post-2020 environment where election officials are under this operational DDoS attack, inundated with FOIA requirements, you know, fielding a flood of them, angry and upset voters who have been fed outright lies and false information from people who have monetized this rage. Election officials are responding to their community. They recognize that these are their people, their clients, their voters. I have to rebuild trust through no fault of my own. I need to focus on that. They're layering that on top of this other panoply of work, including redistricting. Poor redistricting can have impacts on communities. So think about the redistricting process. From an administrative standpoint, it's certainly gotten easier. There's new tools, there's GIS and shapefiles, maps that can be done. But at the end of the day, a lot of election officials are still line by line recoding either addresses, PIN numbers to a new set of districts, or ranges of streets to a new set of districts. These have impacts when there are mistakes. 2018, Virginia, the legislature hung in the balance. Districts had 500 addresses or 200 some addresses, 500 voters in the wrong place. So poor or maladministration, under-resourced administration impact voting and the people who vote in these districts. Think about urban areas, okay? Most counties live in one legislative district or one congressional district. Urban areas, by virtue of their size, hundreds of legislative districts potentially in Cook County, dozens of congressional districts. That means you're remapping you know, the entire pancake stack of political and taxing districts. Just creates a lot of opportunity for error, right? And these errors are being misused in this time. So look, there's a trident of information that voters are getting, that candidates are getting and putting out, that election officials are responding to, okay? And it's, I call it the damaging information trident. First, misinformation, right? Now this is incorrect information shared by good faith participants that increases confusion, raises doubt. Think about a good government group sending all their voters, here's a list of polling places, here's the voting hours, but it's wrong, okay? Okay, they say sorry, mea culpa, the election officials try to limit the damage. That's misinformation. It's certainly going to happen here with districts as there's some confusion.
You should look.
There's also disinformation.
Go ahead. You're on mute right now, Noah. Thank you.
Information. This is incorrect information sent out by, let's say, bad guys, bad faith participants, okay, trying to disrupt, confuse. So think about a bad government group who sends that list of polling places to everybody and the wrong hours, or Democrats vote on Tuesday, Republicans on Wednesday. Okay, that's the type of stuff that election officials have to deal with as well. And then malinformation. This is a technically correct bit of information, usually about innocent, correctable errors, but it's shared in bad faith, out of context, out of proportion to damage, and it damages Americans' faith in elections. If you look back at 2020, the stories that were highlighted out of states or little video clips from here and there, or wrong results up in the northern Midwest from a county, these are technically true, but used out of context, threaded with a storyline to undermine trust in democracy. This is the challenge that election officials are wrestling with while they layer on top, late maps, late coding changes. And so redistricting comes with errors. There will be coding errors. There will be misunderstanding, especially in urban centers. Voters will be moved. They've always voted for this congressman. Why am I not voting for this congressman anymore? They're in a single media market. So there are challenges both for campaigns and candidates to drive turnout, to know who they're talking about, voters on which campaigns to engage with. And this is the thing that disproportionately affect those folks that live in urban centers. There's a lot more stability outside of urban centers just by the virtue of the size, the population density. And so if we think about as there's a political realignment in our country and where people live vis-a-vis, far rural, suburban, urban centers, the impacts, like most in election administration, fall heavily on urban centers and consequently on minority voters. And I'll wrap there and stay for questions.
Okay, great. Thank you so much. And we're bringing in now Matthew Piers, eminent attorney in Chicago, who's appeared in front of me many times. And we'd like to hear his seasoned experience opinions today. Matthew, you're on. Matt, you're on mute. There you go. Okay.
Sorry about that. Thanks very much, Judge Haddad. Every time I appeared in front of you, justice was done. So they're always memorable. And thanks, Nora, and members of the Arab American Bar Association for inviting me to join this distinguished panel to address this issue of central importance to our democracy. What Bill and Nora asked me to talk about was sort of the impact of the efforts to enforce voting rights in Illinois. But because of the national crisis that we're facing, that Derek and Noah and Gary have already spoken to, I'm going to expand my remarks to discuss the situation nationally and suggest some perspectives on where we might go from here. Fundamentally, right, the fight for progress and equal rights in our country only gets waged peacefully, so long as our democracy works well, so long as we have some reliably functioning democratic institutions, the courts, the legislature, representative government, and so forth. And the building block for all of that is the system of franchise or voting. Recognizing this truth, you'd have to say that the passage of the VRA, the Voting Rights Act in 1965, was one of the most profound victories of the civil rights movement in this country. In Chicago, my hometown and the place on the globe that I'm most familiar with, enforcement of the VRA and related litigation has just been essential in the historic efforts to change the political structure of the city, to break up the monolithic regular Democratic Party machine. In Illinois and indeed all over the United States, there is dramatically more diversity in government at all levels, thanks in significant part to the Voting Rights Act requirement of creating districts where minority vote can be decisive or at least have an impact, be influential. The Voting Rights Act, however, being a political creature in a political environment, has been limited in a great many ways. First, on its terms, it's very limited in application. And that's significant in the context of speaking to an Arab American Bar Association, right? The Voting Rights Act protects, on its face, Blacks, Latinos, and certain so-called language minorities, which are then defined in a very limited manner to be Asian Americans, Native Americans, I think Alaskan Natives, and Latinos, if my memory is correct. But it doesn't provide protection to Arab Americans or others. Secondly, and in this country, we're a country of minorities, right? By some definition or the other. So these exclusions are very significant. Secondly, what the Voting Rights Act addresses is racial, national origin, and ethnic discrimination. but not economic or political discrimination, both of which, of course, are widespread in an electoral system that's driven by private funding to such a large extent. And as prior speaker just indicated, right, the efforts to expand the Voting Rights Act to include political discrimination thus far have largely been failures. But the concerns about the limitations of the Voting Rights Act seem almost quaint today. As we face the biggest threat to voting rights probably since Reconstruction, in the form of this well-sustained, highly effective legislative attack on voting rights all over the country that Gary spoke so eloquently about with regard to his home state of Texas. And that attack it's not coincidental. It happens at a time when the federal courts have evolved to something that is a much less friendly forum to deal with voting rights issues, right? From Shelby County in 2013, which stripped away pre-clearance, through Brnovich, which upheld the restrictive laws that the Arizona legislature had enacted, and now the delay on ruling and allowing to go forward of the Alabama redistricting. It should be quite clear that you go to court only when you have to, and only when you've carefully handicapped the likelihood of winning, because they are not anywhere near as friendly a set of fora as they were during much of the civil rights era and the decades since. And what's happened in Arizona and Texas and all over the country is a wave of legislation with one glue, one purpose, and that's to limit the right to vote. The legislative efforts spring sort of ideologically and in a public relations matter from one of the many big lies of former President Trump, that the 2020 election was stolen. I'm from Chicago, and I've run lots of election day operations for lots of elected officials and politicians over the years. And for a few years, I oversaw voter protection efforts by the city of Chicago in the 80s. I'm not unfamiliar with voter fraud, but I can tell you now that for decades now, even in Chicago, vote fraud exists at a truly irrelevant level. It is simply not a significant problem anywhere in this country. And as for the 2020 presidential election, it was clearly the most carefully watched election in our nation's history, and there is simply zero credible evidence of meaningful fraud anywhere in the country. I think that most educated and intelligent folks who care about fair elections know what I'm saying is true. But what many people don't know is that something very significant did happen in the 2020 election, but it wasn't fraud. For the first time, or one of the first times in the nation's history, the large majority of voters cast their votes before Election Day, either by mail or by early in-person voting. Preventing access to voting, such as is taking place in Texas and in Arizona and in a good 20 other states around the country, is an effort to address that fact, not an effort to address any fraud in the election. The fact is that procedures have been put in place that facilitate voting. And when you facilitate voting, more people vote. And in this country, when more people vote, it is often true that Democrats get elected. And for that reason, the right to vote is under attack. And it's under attack big time. And these provisions, early voting and mail ballots, they seem so reasonable. They're so popular. It's a little hard to imagine them as the targets of all this vehemence and all of this legislative effort. But if you think about it as simply efforts to limit the vote, it all makes perfect sense to you. These are attacks by legislatures that want to restrict particularly, but not only, minority voters from casting votes because they vote overwhelmingly for Democratic candidates. And if you think that this is hyperbole by some, crazy old litigator from Chicago, let me give you a few facts. Since Shelby County decision in 2013, the Supreme Court's decision striking preclearance, About 1,600 polling places have been closed across the country, mostly in minority communities in red states. This is a tidal wave of retrenchment of the right to vote. We know that in Georgia, a remarkable political victory took place in the last senatorial election, 2 victories, as a result largely of the courageous trend-setting work of Stacey Abrams and her organization. What was their magic recipe for getting a black guy and a Jew elected to the United States Senate from Georgia? It was voter turnout largely in the Fulton County metro Atlanta area, the old time recipe for how you win elections. And what was the response of the Georgia legislature? They decreased the number of ballot drop boxes in the area from 94 to 23 as a matter of legislation. Why? Because they didn't like the outcome of the election from that part of the state the last time around. And so they want to decrease the opportunities of people to cast their votes. Last year, 2021, at least 19 states passed 34 new laws restricting access to voting. This is not a Chicken Little moment. It's more like the movie Don't Look Up. The sky is really falling. And I think that as members of the bar, we have an obligation to spread the word. Nor, I'm sorry to say, is help on the way. Efforts to address these problems from federal legislation have largely failed and I think are unlikely for a long time into the future. Race-based remedies such as those of the Voting Rights Act continue to be eroded by federal court decisions, including Supreme Court decisions. And I think that it's possible to have a happy ending, but not without a whole lot of effort. We've got to preserve, expand, and modernize our voting processes because we need a government capable of addressing these huge existential issues that we face right now, right? Not just the voting rights problems, climate change, wealth inequality, the global refugee crisis, the international failure of the international health system and our national health system in the face of a pandemic. We need a high functioning government. We don't have it. We don't have it because of political polarization. And the one weapon that we have had is being undercut by the courts and now by legislation, and that is the right to vote. How do we decrease this polarization? Well, real quickly, I think one thing we have to do is consider whether gerrymandering is the poison pill of democracy. You know, gerrymandering is the lifeblood of political polarization. Gerrymandering, politicians pick voters, voters don't pick politicians. The Voting Rights Act is an effort to deal with gerrymandering in redistricting, but it is in a sense another form of gerrymandering, right? It is another form of drawing districts to project an outcome. And that is exactly why it's gotten under attack. So one thing I think has to be looked at is possibility of implementing nonpartisan legislative districts throughout the country. Another issue that is, of corrupting cause here is private funding of elections. I realize these are not small asks, but privately funded elections are profoundly undemocratic. And the outcomes result in politicians who effectively prevent essential government functions and certain critical public policies from being implemented. These are existential problems that we're facing. And our voting system, which is our fundamental tool to get our democracy to answer them, is failing and is under attack. These are huge problems, but there's no avoiding them. We either deal with them or they'll deal with us. And in the hope of dealing with them, I think we need to begin to think how to protect and expand our democratic rights in the context of today's challenges and not merely the perspectives of the past. I hope I've given you some food for thought. Let me shut up, and I hope there's a little time left for questions.
Thank you so much, Attorney Piers. Thank you all for excellent presentations. I'm going to turn the program over right now to our esteemed Professor John Breen from Loyola University School of Law, who might have some questions ready for the panel.
Yeah, thank you, Judge. And thanks to all the speakers for really stimulating and thoughtful presentation. I was looking to see if there were questions in the chat, and unfortunately, I don't see any at the moment. So I actually might open up by asking if the panelists have a question for one another.
Well, I'm going to ask them what tools they have in their toolbox to present in the court of law. I know Professor Bledsoe has been involved in some litigation regarding voting rights in Texas. What is the best approach that a lawyer can take on behalf of a minority to exercise their right to vote?
Thank you, Judge. I would say that the most effective technique, obviously, in terms of enforcing one's right to vote, is to seek to collaborate with others. I know that sounds strange in some ways, but I think that, you know, Matt might be able to identify with this. What I found is being a small-time litigator, that when you do large and major cases, that to the extent that you can join with organizations that do this kind of work for a living, that adds a lot. So I've tried to promote different kinds of seminars, et cetera, where litigators who are interested in getting involved might be able to join with the experts to litigate these issues. Now, in terms of the actual litigation, we have to look at federal court versus state court. And those of you who may live in a state like Illinois, where you might have an appellate court system that's not broken, where people might seek to enforce the Constitution or give some dignity to minority voting interests, I think there is a real avenue in state court. For those of us that are in a state court system that is under siege, especially after issuing a reasonable opinion in reference to mail-in voting during the last election, that we realize that the highest courts in this state are going to be very difficult to access. And so the federal court access is the only way. And to go back to Judge, an earlier comment that you made in reference to the Supreme Court, you know, one of the things I'm hoping that many of the bars can do is start reaching out to these judges, just like we see where Gorsuch is down talking with a federal society group in Florida. I don't know why many of us, whether it's the AABAR Association, the Black Bar, or what have you, are not inviting the law schools or what have you, some of the Supreme Court justices to come and speak and to visit with them and to maybe continue to try and enlighten them about our issues. I think that's going to be extremely important. And the way I look at it, after looking at the Alabama decision, I'm very concerned, and it seems like maybe the Chief Justice realizes he made a mistake with Shelby County. I don't know. I think he maybe didn't maybe understand the gravity of what he was doing. And I look at Kavanaugh, and Kavanaugh, you know, actually wrote a very decent law review when he was in law school about Batson versus Kentucky, to let me know there is some flicker of hope in the 14th Amendment within his view there, that he may be the one. So I'm actually saying let's start inviting Kavanaugh and visiting with Kavanaugh, because the good thing is in the Alabama case, he basically decided on per se grounds, and so he didn't decide in terms of the actual the substance of the issue. He simply decided on procedural grounds. So I think that I would encourage everybody to do that and to provide amicus briefs whenever you get the opportunity. And so we need to start coordinating amicus briefs. And if we get good and open-minded Republican lawyers being part of it, I think that'll be so important.
Well, there you go. The next CLE might be on bringing in judges and justices to talk about minority issues and voting rights. I wonder if we could ever do that. Let's hope in the next 6 months we can. Matt, do you have anything to add to that? I know you had represented some school districts on election issues.
I'm gonna be a little blunter and second some of the things that I just heard Gary say. I mean, be careful about taking these claims to court. I would certainly agree that the Texas state court system is a place to be wary of, but the Texas federal court system isn't exactly like the promised land. And in Illinois, we really have just begun to start testing some of these issues in the state court system. We have, for instance, a state civil rights act, the contours of which have hardly been explored in litigation, that could be very useful in a variety of contexts with judges that are open to these issues. We've got, as federal courts go, we got it pretty good in Chicago still. I mean, I think it is mostly a balanced, reasonable court without tremendous, obvious political bias, in spite of the fact that the newest justice of the United States Supreme Court comes off the Seventh Circuit. But the law's getting bad in federal court in this area. I mean, the Supreme Court of the land has ruled in a series of cases now that the Voting Rights Act is a shadow of what it once was. So consider any litigation very carefully, because in this context, there's not a right for every wrong anymore, if there ever was.
Okay, well, thank you so much. I think that winds it up now. I want to thank everybody for attending, especially the judges I see on the board, and Dean Hill and other people from various law schools. And John, is there anything further you wanted to add?
Just a note of thanks to everyone. I think, the more that we talk about these issues, I think that there's, agreement that everyone wants every eligible voter to vote and to have an opportunity to vote and have that vote counted. And that has to be, but that is also balanced with the idea of legitimacy and confidence in the accuracy of voting. And that's just something we need to work through, as a constitutional democracy.
Special thanks to the Arab American Bar Association and its president, Nuri Yannicki, and for the help of our past president, Maravet Weiss. We'll see you in 6 months, everybody. Thank you.
Thank you, everyone.
Thank you, everyone. Stay safe, everybody. Thank you, panel. Great job.
Thank you.
Great job.
Great presentation.
Thank you.
Thank you. Thank you so much.
All members were outstanding. Thank you guys.
I see Jim Bennett there for a minute. Hi, Jim.
Thank you.
Okay.
Yes.